Again, I'm Stephanie Hudson. I'm the Executive Director of Oklahoma Indian Legal Services. I'm Kiowa, and I grew up in Lawton, Oklahoma. My family is Kiowa. I'm a descendant of Lone Wolf and Kiowa Bill. My grandparents were Ernest and Helen Cloycook, and our family are Elk Creek Kiowas. We are the Kiowas that are furthest west in Oklahoma, in Hobart, Oklahoma. And that's where our family still lives on a lot of land. My mother and my uncle and my cousin, they live in Hobart, Oklahoma on a lot of land that my grandparents inherited from their parents, who inherited from their parents. So my mother has a home on allotted trust Indian land, and it was interesting following her her journey as she tried to have my grandparents' dilapidated home torn down and then building a new home on trust Indian land, and watching the bureaucracy that she had to go through with the Bureau of Indian Affairs in order to just get a home that she could live in after my father passed away. So I'm familiar, not just professionally, but personally, with the time and effort it takes for tribal members to just enjoy the land that they own, to have homes that they can live on, to earn income off of that land. Like I said, my family's very much connected to the land that they've inherited from our ancestors, and it means a lot to us. So yesterday I was joking with Judge Bigler and said, Kiowa, but you're asking me to come talk about 5 tribes land. So that's what I want to do today, is I want to talk about the restricted 5 tribes land. And I want to talk a little bit about the history of it. I want to talk a little bit about the history of allotments. I want to talk about kind of where we're at right now. I want to talk about the Act of 1947, and for those of you who are probably very aware, some of you might not be aware, on December 31st, 2018, the very last day of 2018, there was an amendment made to the 1947 Act, and I want to talk about that and the implications that that's going to have here in eastern Oklahoma. Okay. I want to give a thank you to Casey Ross. She was a great presenter yesterday. She and I collaborate on a number of things, and some of what is in my presentation, she and I kind of share some information, and sometimes we share information that we put in the presentation. So I just want to throw a shout out to her and thank her for some of the information that's in my slide show. Okay, first of all, I want to talk a little bit about Oklahoma Indian Legal Services. As Judge Bigler said, we have been around almost 40 years. We were established in 1981. We grew out of the legal aid of Western Oklahoma. The Legal Services Corporation funds legal aid offices throughout the nation, about 800 legal aid offices throughout the nation. We're one of 5 standalone Indian law programs in the nation. There's Oklahoma Indian Legal Services, there's Michigan Indian Legal Services, there's DNA, which is the legal services for the Navajo Nation. DNA stands for a Navajo name that I am not very well at pronouncing. Professor Sutton might be able to pronounce it a little bit easier than I could. There's Anishinaabe Legal Services, which represents tribal members in Minnesota. And then there's California Indian Legal Services, the largest Indian legal services in the nation. So we're one of 5 programs. We practice primarily federal Indian law. We have a lot of tribal members who call us and say, I need help with custody, I I need help with a bankruptcy, I need help with an eviction. Well, we're not experts on those. We don't do a lot of that, and we refer that out to Legal Aid Services of Oklahoma. They're experts on dealing with issues or low-income people in Oklahoma, so we refer tribal members to that organization. We have 8 attorneys who cover the entire state of Oklahoma for 39 tribes, 31 tribal courts. Most of the district courts in East, we probably have practiced in every single district court in eastern Oklahoma. So I always tell people, we're tired. We're a little exhausted, but we're excited. The attorneys, they're great people, but we primarily practice federal Indian law. We do the Indian Child Welfare Act, wills for Indian landowners, probates for decedents with 5 tribes land interests. We practice in every single tribal court in the state of Oklahoma. I tell people that we're probably the only organization in Oklahoma, I think, that practices in every single tribal court in Oklahoma. There may be, I don't know, Charles Tripp's firm may rival us on that with their child support worker, but I think we're probably close to being the only ones that practice in every single tribal court. We do some constitutional drafting and code development for tribes because we are in every single tribal court. And we see where it's hard to navigate those codes sometimes, and we're always happy to help out with tribes who might need some assistance in developing those. We also go out and do a lot of community education about Indian law topics. If you've got an organization that you want us to come out and speak about one of these topics, we would be happy to come out and talk. Me or one of the attorneys over here. And that's my next slide. These are the attorneys of Oklahoma Indian Legal Services. I'm the one who gets to frequently stand up in front of everybody and talk about what Oils does and talk about what, some of the issues going on out in Indian country. But these are the guys who are out there driving to the point that sometimes their cars have 300,000 miles on them and they're still driving them around Oklahoma. But these guys are the ones who are out there representing tribal members who really do need assistance in these areas of law that nobody is going to help them with. They're not going to help them because, for one, they're complicated things that tribal members deal with Indian land issues. And low-income tribal members who own fractionated pieces of trust or restricted Indian land, sometimes that's the only piece of property that they own other than their home. Sometimes it's the only piece of real estate that they own. And if they've got a small fractionated piece of restricted Indian land and they need it probated, it might be generating a couple $100 a year. It might be generating less than a couple $100 a year. Some people are real lucky and it generates thousands of dollars a year for their interest. But most of them, it's not generating any income. And if we're lucky in Oklahoma, you might be able to find an attorney who will, at the very lowest rate, charge somebody $1,500 for a probate. That's very, very cheap for a probate in Oklahoma. It might cost anywhere from $2,000 to $5,000 for somebody to probate one of these small interests. So we are the ones who go out and assist in those types of probates. Okay. Why do I need to understand Indian land in Oklahoma? We are in a really interesting time in Oklahoma, I think. Steve Hager and I would like to talk about this, is that, this is a cool time to be an Indian law lawyer. It really is a cool time. We got Murphy going on, there's Rakeen with the Indian Child Welfare Act. Tribes are just doing fantastic with economic development. There's more tribal courts out there. Tribal courts are trying to break away from the CFR court and establish themselves. And it's just a really exciting time to be an Indian attorney. But people who are non-Indian, those who are not part of the Indian law world, Us in the, at Oils, we hear quite often, what's the big deal about Indian land? Why are you so worried about the Indian Child Welfare Act? It's just another race. It's, why are you so concerned about these kids who are Indian and you want them to be part of the tribe? What's the big deal with that? And, why do y'all exist? Because, all the Indians are rich from casinos and stuff, so, why does Oils need assistance in order to provide assistance to all the rich Indians who own Indian land all over Oklahoma? So, what I want to do is I want to give you a little history real quick of kind of Indian land, this land status of Indian country in Oklahoma. So understanding what about Indian land in Oklahoma is really important. Most of Oklahoma, not most of, a lot of Oklahoma is Indian country. And there's criminal jurisdiction issues. I think we heard that from Arnold Mickinen yesterday. And he's the master at jurisdiction in Oklahoma, Indian jurisdiction. If you ever have questions, find him, and he is happy to talk to you for a long time about jurisdictional issues in Oklahoma. Civil jurisdiction, once again, he's an expert on that. There's tax status issues, whether land is taxable, whether it's not taxable by the county that the land is located in. And it determines whether the tribe, whether the individuals are eligible for federal programs. So, just a real quick summary, we all understand the relationship between the federal government and the tribes. There's that guardian ward relationship. They have the plenary power over tribal affairs. The United States government has the plenary power over tribal affairs. The United States Congress can say whether there's tribal sovereignty or no tribal sovereignty. A number of us were lucky enough to be able to teach at some of the law schools here in Oklahoma and teach at some of the universities in Oklahoma. And that's one of the things that we talk about with our students and the student interns who come into our office is Congress has the ability to determine whether tribes are sovereign or not. This is not necessarily in our Constitution. This is case law, out of the Marshall Trilogy. So that's one thing that we've always got to remember, is that the federal government has the management and oversight over Indian lands, that the Bureau of Indian Affairs, the Department of Interior, they're the ones who have oversight over the land, the mineral, and leases that exist on Indian land. Okay, so to understand where we're going with Murphy, with Brackeen, with all these cases that are in the Supreme Court right now, I really do believe that we have to understand where we're coming from. So I think we're all familiar with the history that over 40 tribes were removed to Oklahoma, removed to Indian territory. When the tribes were removed to this part of the United States, it was called Indian Territory. And this is where, I'm going to try my little red dot here, my laser. Okay, there we go. It's kind of hard to see on this, I think, but what you can see is that the light tan area right here, that was all Indian Territory. Tribes were removed here from different places in the United States, and only these areas were unassigned, the hatch mark areas, but all of this was former Indian reservations. There were tribal members who were removed from different parts of the country and removed to Oklahoma. The 5 tribes were all familiar with the Trail of Tears, and they were removed here from primarily southeastern parts of the United States. They were forced to walk here. It wasn't a choice of theirs to be able to come here. Yet they were forced to walk here, and 1/3 of those people died along the way to get here to Oklahoma. Tribal members in the plains, They were, the United States government simply tried to eliminate tribes who lived on the plains. And the reason why they tried to eliminate them, and Steve Hager and I had these conversations about, we all hear about the smallpox that was put on blankets and given to them. But they would go out there and just, like animals, go out there and hunt Indians and shoot them and kill them. And Steve's got this great presentation about the Indian Child Welfare Act where they would take the skulls of Indians that they shot out on the plains and take them back to Washington, D.C. so they could study them. They would study, what's the phrenology, is that what it's called, where they look up the bumps on your head to see if you're this type of human or that type of human, and they said, well, Indians aren't human, let's look at the bumps on their head and see what type of species they are and stuff. That's the way the Indians were treated less than 200 years ago. So when somebody says, why don't you get over it? I can't get over it. Because my grandpa's grandpa was born on the plains, and my grandpa understood that, and he passed that down to the rest of the family, how important it was to understand where you came from and how we got here to Oklahoma. So my tribe was signatories to the Medicine Lodge Treaty up in Kansas. And what Santana said was that this building of homes for us is all nonsense. We don't want you to build any for us. We'd all die. My country is small enough already. If you build us houses, the land will be smaller. Why do you insist on us doing this? So the tribes didn't want to be pushed into these tribal jurisdictions in Oklahoma. These were the areas where the tribal members were pushed into, and I think a lot of us are familiar with this, but the 5 tribes have all of this land right here. The Chickasaws, the Choctaws, the Seminoles, and the Skokies, and the Cherokees. That's all 5 tribes land right there. And then the other tribes were pushed into these areas. You got the Kiowa, Comanches, and Apaches that pushed us all together. Kiowas, Comanches, and Apaches. And then the Cheyenne and Arapahoes right here. And they were kind of pushed together too, the Cheyenne and Arapahoes. And it wasn't always happy being pushed together with people that you weren't usually housed with. So, as settlers moved across the nation, the United States government opened land up for the land rushes, sent out advertisements. Land was opened up. Arvo had this picture yesterday. I was watching it and said, he's got the same pictures that I do in his slideshow. But I think all of us are familiar with land runs and how that led to the allotment policy that we still deal with today. We still deal with the allotments that the tribal members were given. So after the land runs, the United States government went forward with Oklahoma statehood. Oklahoma became a state. And there were a number of federal statutes that were enacted at that time. And the purpose of those federal statutes were to diminish the Indian land base in the state of Oklahoma. And what came out of the opening of Indian Territory was the General Allotment Act of 1887. And it's commonly known as the Dawes Act. And what it did was it broke up those reservations that we saw on the previous map with the different colors of the reservations. What the Allotment Act was, it broke up those reservations and forced tribal members to accept small pieces of land. They considered it small. 160 acres. My husband would go, oh, 160 acres, that's going to give me a whole bunch of room to go hunt and run an ATV on there and all that and everything. But for a tribal member who was used to traveling from Montana, Canada, Wyoming, traveling that area with their families, with other tribal members, and following the buffalo from way up in the northern part of the United States, sometimes all the way down to Mexico. And tribal members who were used to doing that, 160 acres was just, utter devastation. Utter devastation to be placed on 160 acres and told, this is where your family is. But we're going to place your brothers and sisters over here, away from you, and we're going to give them another allotment over here. And the whole purpose of that General Allotment Act was to separate the families. We see when we're doing land research and stuff that there'll be allotments over there in McCurtain County, then there'll be allotments over in Jefferson County. Has anybody ever driven from Waurika to Idabel? I have. And it is a long drive. So can you imagine family members having to communicate with each other, to have, to do something with each other? Back in the 1800s, it's like us living here. My sister lives in Europe. It's like, trying to, it's an impossible task to be able to see the person very often. So like I said, that was the allotment process. The United States was carrying out their trust responsibility, a guardian-ward relationship. We're the guardian, and the Indians are the ward, and we're going to take care of you. And the way we're going to take care of you is we're going to give you a home, and we're going to give you 160 acres. Okay, so Senator Henry Dawes, he believed, and the Dawes Act, this is who this is named after. He believed that I spelled that wrong. Private property had the power to civilize, and the Dawes Act is named after him. He wanted tribal members to remain within the reservation boundaries, but then, be on individual allotments at the same time. So what happened was, with the opening of the lands, with the allotments being given out, little towns being settled in Indian territory, what you wound up was this real mix of town sites, settlers coming in from the land runs, allotments in there, and you round up with a checkerboard pattern. And the allotment was devastating. It's the most devastating piece of legislation for tribes that exists. And it slashed millions of acres from existing land base, both broke up tribes as communal units, threatened tribal sovereignty. And it was all part of this effort to try to get rid of Indians in the United States. There was removal, there's the Indian Wars, there's allotment, there's boarding schools, there's relocation. And what I want to say is that all that happened, and look at us. It's 2019, and we are at a conference talking about current Indian law issues. I think it's just amazing how resilient tribal members are. So this is the allotment process. That's 160 acres. In our office, we use those a lot. The document on the left, when we're trying to figure out where land is and how much land a person still has. So, that's the original allotment right there. And then the document on the left shows how those allotments are kind of broken up. And that's not the same thing, but it's an example of how land is such a checkerboard in Oklahoma. Well, let's call it, you drive down I-35, drive down I-40, and you are probably driving through fee land, restricted Indian land. There might be some trust land out there. Drive through Okima, that's a town that you're driving, a municipality. So you're just going through different pieces of land as you drive along, and that's what Oklahoma is. That's what has come out of the allotment process, is just a mishmash of different types of land. And I would say that's why Indian land is so fascinating. It's complicated, but it's so fascinating because you get in those land records and you can kind of see the history of a family. You see who owned the land, who did they give it to, who did they sell it to, who took it from them. Oh my gosh, these guardian deeds that are out there. Tribal members back at the turn of the century, not the recent turn of the century, the 1900, not just children, but adult Indians were given guardians, and the guardians were to look after the land, and those guardians would sell the land under a guardian deed, and that would be recorded in land records. And we see those all the time, and then the guardian took a huge fee for being the guardian of that tribal member, and then they would give the tribal member a little bit of money in order to get by and stuff. So checkerboarding is just a devastating occurrence that happened in Oklahoma. Like I said, we're still here in spite of all of that. So, when I went to law school, I knew who Lone Wolf was. My family talked about Lone Wolf, and they talked about how important he was in our family. And I was reading a book by Blue Clark. He's a professor at OCU and a Muskogee historian. And he wrote a book called Lone Wolf v. Hitchcock, and the implications of that case in Indian law. So I was reading his book and I saw this picture in there. And I had to look at it twice, and I had to show my mom it. And I said, Mom, that's Lone Wolf and Kiowa Bill sitting on that chair. And she and I had a discussion about it. We looked at other pictures of Kiowa Bill and everything. And sure enough, in the caption it said, this is Lone Wolf and Kiowa Bill when they went to the Supreme Court to go fight the allotment process. Lone Wolf is my grandfather's grandfather, and Kiowa Bill is my grandmother's grandfather. And this is before my grandparents were born. And I was just amazed that they went to the Supreme Court together to fight the allotment process. They filed papers with the help of farmers who didn't want, rangers who didn't want the barbed wire fences put up and everything. And they went to the Supreme Court to fight the allotment process. And it's an important case in Indian law because Kiowa Bill lost the case. He did not prevail in the Supreme Court against the United States government. And this is the case. It's not important just in federal Indian law. It's important in other constitutional law cases because it sets out that the United States government has the plenary power to abrogate obligations, treaties, between the United States and Native American tribes unilaterally. The United States government can not honor treaties. Okay. So, is trust Indian land the same as restricted Indian land? We get that question all the time, and when we're teaching law students, there's just always this mix of trust Indian land, restricted Indian land, and calling it different terms and stuff. In Oklahoma, there's a real distinction between trust Indian land and restricted Indian land. And it's whether you're dealing with the General Allotment Act or the Dawes Act. The General Allotment Act dealt primarily with the tribes who were not the 5 civilized tribes at the time. Don't use the word civilized today, it's 5 tribes. Okay, we've learned that in our office. But at the time it was called the 5 civilized tribes. The General Allotment Act dealt with the tribes primarily who were not 5 civilized tribes. Then it was called the Dawes Act. But the Dawes Commission, after the the General Allotment Act, the Dawes Commission was set up, and they sought agreements with the 5 tribes. The negotiations failed. The 5 tribes, they were called the civilized tribes, but sometimes they, were not agreeable, just because they were 5 civilized tribes. They were not agreeable to these allotments that the other tribes had been placed upon them. So when the negotiations failed, then the Dawes Commission just said, well, we're going to do it anyway. And they set up the Dawes rolls, where tribal members, under the Curtis Act, they set up the Dawes Commission. It called for allotment of the 5 tribes, no tribal consent. Plenary power of the United States government can unilaterally do what they need to do for the protection of 5 tribes. So what the 5 tribes wound up doing was negotiating agreements. The Dawes Commission compiled the completed rolls. These are the Dawes rolls. When 5 tribes members are trying to determine their ancestry and to determine whether they are a member of a tribe, they look to the Dawes rolls. And only those whose names appeared on the rolls were eligible to receive allotments. And before statehood, these were some of the agreements that were made between the 5 tribes and the federal government. Here's some more agreements made between the 5 tribes and the federal government. There's some more statutes that were made between the federal government and the 5 tribes. So, during the allotment period, between 1887 and 1934, 219 reservations across the whole United States had their lands allotted. A total of 27 million acres passed to non-Indian ownership by 1934. Can you imagine all of that land that tribal members had been placed onto, and then a lot of it was gone by 1934. And so in 1934, the Indian Reorganization Act ended the policy of allotment. But those restrictions still remain. 120, 130, 40 years ago, the federal government put allotments in place, and we're still working with those in 2019. So, restrictions for 5 tribes allotments, there was land allotted under the General Allotment Act. There was land allotted to the 5 tribes under the Dawes Commission, and it was the Cherokee, Muskogee, Seminole, Chickasaw, Choctaw, and then the Osage. Mr. Tinker, you have your own set of issues that we deal with and everything, so the Osages have different ways to deal with stuff. So, who is an Indian? For 5 civilized tribes, federal purposes, is based upon the blood quantum. And it goes back to who was on those original Dawes rolls, who was an original allottee on those Dawes rolls, and their descendants. Whether you're a member of the tribe is based upon whether you're descended from that original allottee, and your interest in the land is based upon what your blood quantum is and whether that person was on the Dawes rolls. Okay, so the Act of 1947. The reason why I'm singling out the Act of 1947 in all those statutes that were on those 3 slides, why is the Act of 1947 the one that we're going to talk about, is before December 31st, 2018, I made a mistake there again, these were the most substantive changes to restricted property rules. Before December 31st of 2018, the Act of 1947 was the act that we all went to decide who owned the land, whether the land was taxable, whether it was restricted or non-restricted. We went to the Act of 1947. And I keep an Act of 1947, the Act of 1908, and the Oklahoma statutes. I keep those on my desk. so that when I'm working on a probate, I can go back and look at that act now, if I have to. But it added additional federal bureaucracy. The county courts of Oklahoma are vested with jurisdiction. It's restricted Indian land, it's fee land, with restrictions placed upon it. So the land is probated and administered in the county courts of Oklahoma, but the federal government has restrictions on it so that anything that has to do with that fee land that you're dealing with in the courts of Oklahoma, you have to make sure that you're cooperating with the federal government and the Department of Interior as you're probating and administering that property. The Stigler Act amendments. The Act of 1947 is the Stigler Act, and there were amendments to that on December 31st, 2018, and we're going to get to that at the very end of this presentation. But the Act of 1955, it was also extended some of the restrictions also, so that's always something that you might want to look at sometimes. So like I said, what does restricted mean? It's restrictions upon alienation. It means that if you are a owner of land that you inherited from somebody who was an original enrollee, and that land was allotted to them during the Dawes Commission, and based upon the Dawes rules, then there's restrictions on it. And those restrictions are based upon blood quantums. If somebody inherits that land, and before December 31st, you had to be more than 1/2 degree of any of the 5 tribes. And sometimes that takes a lot of work for us to figure out blood quantums. Some people didn't enroll, and there's ways that you can enroll somebody who wasn't enrolled at the time of the Dawes rolls. You have to work with the enrollment. It's a complicated process. We don't get involved with that usually. But we have to take that into account. If somebody presents himself and wants to deal with a will or a probate, and they say they are 3/4 Muskogee, we kind of go, are you 3/4, or is there a grandpa or grandma out there who wasn't enrolled? And we need to take that into account. So that's what a restriction is that is the fee land, and there is other things that need to be done in the county court and deal with the Department of Interior. Everything that's done with the land must be approved by a district court judge. And we have lots of questions in our office about what is the definition of a district court judge? Is it a special district court judge? Is it an associate district court judge? What we do in our office is we try to find the district court judge of that county. And in Oklahoma County, it's special court judges that deal with the probate docket, and we have them do the probates and do the will approvals and stuff. But Indian country, the allotments, they're under 28 U.S.C. section 1151 under C, when we were talking about the jurisdiction last year. And the Act of 1947, and dealing with probate, you have to take into consideration what the definition of an Indian is. In the Act of 1947, an Indian is going to be somebody who is descended from somebody who was an original enrollee on the Dawes rules. Okay, so the governing law for restricted Indian land in Oklahoma is Oklahoma law. We primarily look to Title 58 of the Oklahoma statutes. Intestate succession, when we're dealing with somebody who passed away without a will, you're going to get probated administered according to state law. Will requirements, you're going to probate wills for restricted Indian land according to Oklahoma state law. The forum for probates of restricted Indian land It's the county court where the land is situated, or the county court where the tribal member resided at the time of their death. We start our probates with a death certificate. We don't start anything until our client sends the death certificate in, and we go by the residence on that death certificate. Civil procedure, you go by Oklahoma civil procedure. This is the area that probably, there's a couple of areas, if somebody is going to make a mistake on a probate for a 5 tribes member, this is probably one of the big mistakes. Valerie Giebel, back there with the solicitor's office, she probably sees the one who deals with this. Is, if somebody is trying to probate land, restricted Indian land, and they don't give notice to the regional director of the Bureau of Indian Affairs of Eastern Oklahoma, then that probate can be invalidated. What would happen is if you start the probate process and the Bureau of Indian Affairs or the Department of Interior find out that a probate's going on for a member of the 5 tribes with restricted Indian land, and notice hasn't been given to the regional director, you're probably going to get a letter in the mail from Valerie or Connor Cleary or somebody that says that you have to comply with the federal statutes that require that you give notice to the regional director of the Bureau of Indian Affairs for the Eastern District of Oklahoma. So that's one of the things that you got to make sure that you do. Land that has fallen out of restriction, just generally, land that has fallen out of restriction cannot be placed back into a restricted status. Sale of land, sale of restricted Indian land, you have to go to court in order to get approval by the district court judge. And if you are working on the sale of restricted Indian land, the solicitor is going to appear and they're going to kind of take over the proceeding, and it's their responsibility to make sure that all of the procedures are followed during the sale of restricted Indian land. Okay, I'm going to zip through a little bit since we're talking about the Stigler Act right now. The rest of it was just generally, with the allotments for land issues that is dealt with through the federal government. Okay. So why are we all here? We're here to talk about the Stigler Act, the Act of 1947, and how do we deal with the amendments of 2018. That's the site right there of the amendments. The 5 tribes, they've been working on this for a number of years, kind of silently, kind of diligently working on this. I tell people that the Intertribal Council of the 5 tribes, my belief is that that's the strongest, the most powerful governmental unit here in the state of Oklahoma. And they worked behind the scenes to try to lift, not behind the scenes, but diligently, quietly and stuff, working through the proper process to make an amendment to the Stigler Act so that land didn't fall out of restriction if a person who's less than half of any of the 5 tribes. So that land would stay in restriction for tribal members. So land would keep its status as Indian land, Indian country. So what are the implications of this? And what I wanted to do was I wanted to go through 6 different questions real quick. Should the Stigler Act amendments be interpreted to preserve the restricted status of all restricted property or interest in the estate of a 5 tribes Indian, or at least 1/2 of the 5 tribes, regardless of the decedent's date of death? What that question is asking is, if a 5 tribes member passed away in 2000, in the year 2000, and their land was restricted, and the family member calls Oils tomorrow and says, I want to probate my Uncle Joe's land, and he was 3/4 Choctaw, but he died in 2000, but the act is in 2018. Is that land going to stay restricted? And the answer is yes. The act says that if the persons, I got this written down, the general intent was remove the blood quantum requirement, and the act extends the restrictions on currently restricted land when acquired by anyone who is a lineal descendant. And regardless of the date of death, the entering of a final order determining heirs, even if that person died before the enactment. So, if you want to probate the estate of somebody who passed away before the enactment, and they have restricted interests, regardless of what is going to happen with their blood quantum, that land is going to stay restricted. Okay. So question 2. If the answer to number 1 is yes, if the land is going to stay restricted, does the number of deaths in the chain of title affect whether the land is going to stay in restriction? Yes. If you have a deceased allotee and they were 3/4 of the 3/4 degree of the 5 tribes, and then you have somebody in the chain of title who was a direct heir and their blood quantum is 3/8. Okay. So the original allotee was 3/4. When they passed away, if the direct heir had probated their estate, the land would have gone out of restriction because they were less than 1/2 of the 5 tribes. Now what the act says is that when you probate both of them, then the land is going to stay in restriction. So when we deal with probates, there's lots of chain of title that we're doing multiple probates in order to get that title up to date. With the act now, no matter what the blood quantum is, and if you start the probate today after the act has been enacted, the land will stay in restriction. Okay, question 3. Is this going to affect oil and gas leases that were obtained prior to the Stigler Act? And the answer is no. If there was a lease that was put in place before the enactment of the Stigler Act is not retroactive to that lease. That lease is going to stay in place, and it's not going to affect that. So question 4 deals with the royalties on that lease. If there is oil and gas leases that were on unrestricted land that came from an original enrollee, but the land was unrestricted, and the lease was not approved by a district court judge, the question was, now does that money have to go into an IIM account? Because those of you who are familiar with dealing with leases of restricted Indian land, the lease money from that has to go to the Department of Interior and be put into an individual Indian monies account. And what my question is does that money have to go into an IIM account if the lease was unapproved by a district court judge? No, it's going to go directly to the landowners in that situation. Okay, question 5. Should the Stigler Act amendments be interpreted to reinstate the restricted status of lands which were conveyed to another 5 tribes member by a court-approved purchase for value or partition sale prior to the date of the Stigler Act amendments? What that question is asking, it deals with restricted Indian land that was purchased for money by somebody. When restricted Indian land is purchased for money by somebody, it loses its restrictions. It's no longer restricted land, it's fee land. And what the question is asking is, now with the amendment, are those purchased lands going to be restricted now? No. That my opinion is no. And finally, must notice of all probates of estate states of Indians of the 5 tribes. We served on the regional director of the Eastern Oklahoma Regional Office of the Bureau of Indian Affairs, regardless of the blood quantum of the decedent. Yes, this is going to increase the number of probates that are going to need to be probated through the district court. You're going to need to give notice to the regional director of the Bureau of Indian Affairs. So the whole idea of the Stigler Act amendments was to incentivize probates. So our office is hoping we're going to see a lot of people coming to us who need probates done. Those of you who do estate work, what I really ask of you is if a tribal member comes to you and they own restricted Indian assets, and that's about all they own, is see if you can work out something with them. It's not a complicated process. You just follow the Oklahoma statutes and make sure that you're giving notice to the regional director and such. Cooperate with them. If you ever have any questions about how to do these probates, call us, email us. I think I've got our information out there. It's a little small on that one. But call us, contact us. Any of our attorneys, me, Nikki Lindsay, Yvonne Gailey, Jacinta Webster, we do a tremendous amount of work with probates of the 5 tribes. Case and Jeremy, they're a little bit newer. They deal mostly with criminal and ICW, and Steve, he's our ICW expert. If you ever have any question about the Indian child welfare, I call Steve and talk to him. But if you ever have any questions about this, we're happy to come talk to you. And we like doing these programs where we talk to people about what we do. So thank you very much.